Hotel, Casino, and Spa.
Your Honor.
Yes. Can we have appearances, please?
Good morning, Your Honor. Ethan Thomas with Littler Mendelson on behalf of the plaintiff. And I'll let my colleagues introduce themselves as well.
Good morning, Your Honor. Crystal Eller, Assistant General Counsel for the Clark County School District.
Good morning, Your Honor. Andrew Clark with Littler Mendelson for the school district.
Your Honor, Bradley Schrager of the law firm of Bravo Schrager here for all the defendants. With me today in the courtroom is John Velardita, the defendant, who is not only here, he is intending to testify before the court today.
All right. Are we ready to proceed?
Yes, Your Honor.
I am, Your Honor.
Okay. This is motion for temporary restraining order brought on behalf of the school district against the Clark County Education Association on an order shortening time. You can proceed.
Great, Your Honor.
May I ask one housekeeping question?
Sure.
Which is, given the fact that I intend to put Mr. Velardita on the stand, is there any particular order you'd like to do this, or just statements followed by my statement, followed by putting him on the stand, followed by statements? How would you like to proceed through this process, given that information?
Apparently, this is an evidentiary hearing now.
Okay.
So I think that would be an appropriate way to proceed. As the argument continues, we can have the witnesses
Very good.
standing sworn in.
Thank you.
Good morning, Your Honor. Unfortunately, we're back here today after we were here 3 weeks prior before Judge Peterson, seeking a similar injunction against the defendants in this case. But at that point in time, since then, not only have threats taken place, which is what we came in previously requesting an injunction for, but as now it's clear, and we have provided evidence that there is a rolling teacher strike that has occurred and is ongoing throughout Clark County. Since September 1st, there have now been 8 schools in Clark County that have had to cancel school as a result of the actions of the defendants and the educators they represent. This includes Newton Elementary School, which was canceled this morning. We didn't even have an opportunity to file another supplement for the court, but we've had one more school closure today. In that time period, since September 1st, there have only been 7 school days where kids are actually in school during that time period. So we've had 8 cancellations on 7 actual school days. A strike is defined under NRS 288-074, and it's defined very broadly. We discussed this ad nauseum in front of Judge Peterson previously, but because you're new to the matter, Your Honor, I wanted to just walk through a few important points related to the statutory structure. The strike is any concerted stoppage of work, slowdown or interruption of operations by employees of a local or state government employer, absence from work by employees of a state or government employer upon any pretext or excuse such as illness, which is not founded in fact, or the third definition of strike is interruption in the operations of the government employer by any employee organization or labor organization. NRS 288-705 is perfectly clear that if a strike occurs, CCSD must move to enjoin a strike. We didn't have an option anymore. We had to move because we believe a strike has clearly commenced. All the statute asks is for us to set forth the facts that constitute a strike in our application for an injunction. The statute then indicates that if the court finds that an illegal strike has occurred, or unless enjoined will occur, it shall enjoin the continuance or commencement of such a strike. When we were here previously, Your Honor, we were arguing that a strike was going to occur. We are now past that point. And so the only finding that the court needs to make is, has an illegal strike occurred? And if that has occurred, you shall enjoin the continuance of the strike. That's straight out of NRS 288-705. This really is a narrow request that we're making here today, that you enter a restraining order and a preliminary injunction enjoining CCEA and its bargaining unit, the defendants that they represent, from the continuance of the striking activities. That is why we're here today, Your Honor. Contrary to the arguments that were made in the opposition filed by the defendants yesterday, there is ample evidence to support that a strike has occurred and that an injunction request is necessary in this case. The evidence in our filings present and demonstrate a history of public statements by the defendants and other CCEA members that outline a clear plan to strike that has been in the works for weeks, and the purpose of doing so was that they would do so if their contract was not ratified to their liking, to their demands at the bargaining table. This is no longer a situation, as I mentioned, where we're questioning, will a strike occur? That was what Judge Peterson was struggling with before, because she wasn't sure if the injunction if a strike was actually going to occur. We are well past that position at this point in time.
Just for a second. Just so you know, I watched the jazz of the recording of the entire hearing, and I have consulted with Judge Peterson on this.
Okay, great, thank you. And so I am going to walk through because the defendants argued in their motion that we have presented no evidence of their involvement and of really of everything. They contested that there's not even evidence that these absences from work are coordinated. So I'm going to walk through some of the key facts. I'm not going to do everything, but I am going to walk through some of the key facts because I think it's worth remembering. On July 12th, defendant Velardita stated on a radio program that this is really serious because we've been told and been directed by our membership that, there's not going to be a school year without a contract. The threat he made that day has clearly been blessed by his membership. Then on July 29th, which was immediately before we came to court the first time and filed this action, Mr. Velardita reaffirmed the plan to strike if needs were not met, that they would target certain trustee members' districts. He then immediately clarified that the plan was still in place by the union. He stated, if we do not have an agreement with the school district by August 26th, our organization and our members will be taking a vote to engage in work actions. And those work actions that we will have to take will not be district-wide initially. They will be what we call selective management. We will target a trustee's district at a time, where if we don't have a contract by then, it could very well be that those schools are the schools that engage in work action. We've provided evidence to the court, and we've presented we've blown it up for your consideration here today, and it's Exhibit 8 to our renewed motion. And it shows that defendants clearly have presented and instructed CCEA membership on a potential action that could be taken that's nearly identical to the rolling sickouts that have recently swept through Clark County since September 1st. The image shows a PowerPoint slide shown in what appears to be a CCEA membership meeting. It shows that CCEA members were clearly presented with this option of engaging in what the slide calls a rolling school outs. The bullet points in the slide: selective engagement, one trustee district at a time, selective sick outs.
Your Honor, I'm going to object that even in their own papers, the administration authenticate, have no notion of its invisibility, and have no information about this slide.
This isn't an evidentiary hearing right now. This presented to the court.
It is an evidentiary hearing. So I'm going to at least raise the objection. Please
Hold
support
on.
this.
Address the court, okay? Are you moving to admit it as evidence?
We are. We included it in our filings, and we do believe that it should be admitted as evidence, Your Honor.
Okay, and the objection is there's no foundation to admit it as evidence.
That's correct. They have no authenticating ability. They haven't even tried to authenticate it, and they admit it in their papers. They have no ability to do so. Your Honor.
Okay, the exhibit is not admitted as evidence. However, the court is taking it as a demonstrative.
Yeah, and I'd like to address that point, though, Your Honor. We admit that we were not in the meeting in question,
Understood.
but the photo is in our possession. It has been provided to us by a third party that was concerned about these issues. It was provided to us by them. I don't know how we ever could admit it without conducting some discovery. Or where we could authenticate it essentially.
Understood.
But the statements made by Velardita on July 29th that I just read are almost verbatim what that slide presents, which he made to the public. His own statements authenticate that this is legitimate. We invited them.
They do not, they authenticate nothing.
We invited them in our filing on Monday to put under oath that this is not an authentic document, or that they did not show this to their membership in one of their recent meetings. They clearly chose not to do that. I think you have to. I think they submitted a filing yesterday. There was no declaration from Mr. Velardita or anyone else that indicated that this was not an authentic document or an authentic image of something that was presented there. They did nothing to change or argue that the context in which we presented it is incorrect, or that they never showed this to their membership. I think there's a reason that they didn't do that. I think it's very clear that the reason they didn't do that is they can't say under oath that they didn't show this to them. They can't say under oath that this is not authentic. So they've tried to dance around, and they've presented a declaration from someone else that doesn't say that this is an inauthentic photo, an image that was shown to people. It talks about actually a meeting that we don't even believe this was the actual slide at the meeting that she provides her declaration for. Her declaration that they provided in their filing yesterday talks about what occurred on August 26th. We believe this photo was taken on July 29th at one of the membership meetings a few weeks before what happened on the 26th.
It's understood by the court, and I'm not missing the fact that Mr. Velardita's comments, which nobody disputes were made, are consistent with what's on the slide. What I'm saying is, because it can't be authenticated, we don't know if this is a true, accurate copy of whatever picture was taken, if it was edited. So therefore, it's not being admitted as evidence. The court's reviewing it as demonstrative, and we'll move forward under that.
Okay.
Any other objections? Counsel?
No.
Other objections? Okay, thank you. Go ahead.
But I think that's part of the problem, Your Honor. They can't have their cake and eat it too. They can't argue that we're failing to present evidence when the evidence we do present, and all they're doing is hiding the ball. I will admit that they have been as clever as they possibly can be in trying to hide the fact that there has been a clear plan in place to strike. Ever since we filed the complaint and initially sought this motion, some of the rhetoric of the defendant Velardita has certainly cooled down, and they've clearly moved towards working in more surreptitious ways. And their failure to really provide any evidence that this is an authentic photo, I do think is telling, regardless of whether it's admitted right now or not.
Understood.
We have also provided evidence of the defendant's challenge that there's no evidence that this is actually a strike taking place, that these are not legitimate absences, and they posed things like, oh, well, it's cold season, there's COVID coming around again. Quite frankly, I think that creates a mockery of common sense here of what's happening. We also did present in our motion, though, and we provided video evidence of a TikTok post by a CCEA member whose TikTok handle is One Fed Up Teacher. And in that, she all but conceded that the mass teacher absences are concerted and pretextual. She stated she has it on good authority that the teachers are just taking matters into their own hands and have said enough is enough. You also, when we presented another media report with an anonymous CCSD teacher who was interviewed by Mike Allen at, I believe, by Fox 5, and we presented the article that was in there. And in that, the teacher acknowledges as well, some of us feel that the only way to get through to Dr. Jara, the superintendent, and his trustees, is if instruction is interrupted. to gain some sort of positive change, there's got to be some sacrifices in order for that change to happen. Indeed, the en masse sick calls are coordinated and could keep happening until the district acquiesces to CCA's demands. There's no question that these sickouts have been coordinated. And then yesterday in our supplemental filing, we also provided an exhibit that from an anonymous complaint that was sent by a licensed educator at Southwest Career and Technical Academy.
Your Honor, I will lodge the same objection to that apparent evidence from last night that there's no authentication and no ability for anyone to respond to it.
Okay. This particular piece of evidence, the name of the teacher that sent the emails was redacted. However, had it not been redacted, we can certainly authenticate that teacher's email and that teacher sent those emails, although we don't know who sent them to the district. So, assuming that we can authenticate who the teacher was, and for the protection and privacy, the district did not include it, I don't have an issue with authentication on those emails. So, admitted.
And in that anonymous complaint that was filed, and we did redact the teacher's name that was being accused of this conduct just for their own privacy, Your Honor. Obviously, we're willing to provide that in camera in some respect if it's necessary. But in that filing, they were accusing this teacher, a CCA member, of that they had become a leader of SWCTA's strike efforts and mobilized teachers to take a day off on Tuesday, September 12th and Friday, September 15th to disrupt instruction. According to the complaint that was made by this educator, a CCA member was using private email addresses to help coordinate the sick out. You can see in the exhibit the actual email, a screenshot of the email that was provided where they're basically giving the order. Today's the day, 9/12, and then after that, many people called in sick, and then obviously school was canceled yesterday. But one of the more telling pieces of evidence in that complaint as well was an email by that same teacher who's being accused of coordinating all of this, a CCA member, where he says, hey everyone, for those of you who are new to unionization and labor movements, it's imperative that your direct supervisors or anyone with power over you in the workplace are not part of the conversation. Legally, it puts both parties at risk. And so he's directly linking these efforts that he's undertaking to unionization efforts and the labor movement. And so there is clear evidence that these things are pretextual. That amounts to a strike under the statute. It's clear that they have been guided, encouraged, and helped and aided these educators in substantially interrupting the district's operations, and it amounts to a strike under the statute. Now, I want to also point out something that the defendants argued in their motion yesterday. They want to set up that the burden in seeking a temporary restraining order or an injunction is essentially akin to proof beyond a reasonable doubt. That is not what is required. We must show likelihood of success on the merits, which courts in the Shores and Global Experience case indicated is only showing a reasonable probability of success on the merits. But what is success on the merits in this case, Your Honor? It's, have we shown evidence that a strike has occurred? There's no other causes of action in this case other than for declaratory relief and injunctive relief. The success on the merits is, can we show that a strike has occurred? If a strike has occurred, the court shall grant an injunction to stop the continuance of the strike. We've clearly met that burden from the evidence and the exhibits that we've submitted. And I think, quite frankly, Your Honor, we're really at a position here where this is an action in equity. The defendants have done everything they can to hide the ball, hide what they're doing. And we would argue they don't have clean hands based on some of the things that we've presented to the court. The court must consider that in coming to its conclusion. And really what the TRO is about keeping the status quo. Teachers should not be striking. It is against the law in Nevada. There's no dispute about that. They say that oftentimes in their briefing, that there's no dispute that that's what the law is. So the status quo is you're either going to grant the TRO here today and get us back to the status quo, or we're creating a completely different status quo that allows them to skate and hide their activities and allows them to keep calling in sick and escalating the amount of things that are going to keep happening. This strike will keep going. It will continue to escalate. As I mentioned, we've had 8 cancellations within 7 days. You really have those two choices. Are we going to go back to the status quo, which is strikes are illegal, or are we going to allow them to play this game and try and skirt around the real meaning of the law, which is to prevent public employees from striking? And the legislature outlawed this 50 years ago, and the defendants in this case have clearly helped their members effectuate a strike, and they must be stopped. I'll reserve some time afterwards, Your Honor.
Thank you.
Thank you, Your Honor, and good morning. Once again, Bradley Schrager for the school district. I'm always slightly perturbed, if not amused, when I'm told that the greatest evidence someone has is that there's no evidence. Or at least that the evidence doesn't go to do the things they needed to do to reach the level of extraordinary relief of what would be the first ever injunction against a teachers union in joining a strike. And I want to take particular care to identify what counsel and the district means when he says they, because there are individual defendants here and CCEA. Those are the only parties that are in the lawsuit. It's not an amorphous group of teachers out in the world. Right? You don't have jurisdiction to do that, and the union can't control every teacher out there in the world. Now look, I'm not here to deny objective reality. Clearly, I understand the situation, and teachers have called out sick, and a comparatively small number of schools have had to remain closed on certain days. That's true. But there are particular problems for this court in considering issuing an injunction, and those two major problems, and I'll be as concise and clear, and I isolate those from the 100 pages you got. We got it after hours on Monday night. You got it very quickly, dropped into this case. I'm going to isolate what I think the problems are, because they are, number one, evidentiary, and number two, they have to do with if you agreed that an injunction might be possible here, what an injunction would look like under the normal powers of a judge to do so. Now, I also want to stop and say, I've already said clearly, teachers are calling out sick. Schools have closed. No one's saying that's not true. But what percentage of teachers calling out are ill? We don't know. The district doesn't know. On every single day, out of 18,000 teachers, some of them call out sick, which they are perfectly able to do under their contract and under labor law. Most of them are perfectly legitimate. What is the level of call-outs on any particular day that a school can handle and maintain instruction, stay open? I don't know. You haven't been told. We haven't examined any individual school's circumstance or the circumstances of any individual teacher who has called out sick in the period that the district has identified. I assume that the level of call-outs that would cause a crisis are dependent upon different things in different situations. The staff that the school already has in place, meaning whether they have already an inordinate number of vacancies that it has not been able to recruit for whatever reason, whether a suitable number of substitutes are available, and of course the discretion of the school principal and the district to maintain or not instruction for that day. Those are variables that no one can control. All of those create a problem for the court in fashioning a potential injunction anyway. But as I said, I want to go back to the two major problems: evidentiary, statutory, and the potential for fashioning an injunction. The court's dilemma is that you can harbor discomfort, you can harbor unease about the situation in our schools, You could harbor unease about everything the district has brought up, but that is very different from your responsibilities as a jurist when you're considering extraordinary relief of an injunction. Because with all the materials showing whatever level of teachers' absences there have been, the district hasn't amended its initial complaint. There are 4 defendants. Those are the defendants that need to be shown that have created a strike by concerted action. That's the linkage that has to be shown. Not the mere fact that schools are not opening or that some teachers are calling out. And in fact, the statute says, and this is 288.074, subsection 2 in the definition of a strike, one of the definitions is or local government employees, these teachers, upon any pretext or excuse such as illness which is not founded in fact. I don't know of any facts that have been brought to you regarding that other than the fact of it happening. Could there be pretextual absences? Certainly. You haven't been shown that. That's what needs to be activated for the court to consider issuing an injunction in this situation. But what evidence do you have that any of these 4 defendants is coordinating some secret plan to have teachers call out sick illegitimately? There isn't any. So when we say they haven't brought any evidence, it's not that there's no evidence that something is occurring out there in the world. It's evidence lacking that my clients are responsible for coordinating, supporting, or doing it, that they are creating that concerted action. And the district knows that, or it wouldn't say in its paper 6 different times, even if they're not doing it directly, or nonetheless, or this may not constitute actual evidence, however, reason tells us. That is not sufficient. They have not offered anything establishing that CCEA, Mr. Velardita, Ms. Nices, or Mr. Frazier is coordinating, encouraging, advising, or in any way linked to any unlawful strike activity. If they did have that evidence, it would be incredibly prominent, right? And that actually reminds me, I think we're sort of done with this for now. You don't want to do that? Thank you. So what is that evidence? And I would sort of ask, and of course you don't have to answer this, I ask it sort of rhetorically, but I'm sort of interested. What's the strongest piece of evidence linking these 4 defendants to the conduct of any unlawful activity? Is it the TikTok account? Is it this unauthenticated slide that can't be admitted into evidence? Is it, what is it? Is it a newspaper report or an editorial? What is the thing that shows it? Is it the anonymous email last night that can't be revealed that is also not from anyone connected with the leadership of CCEA or CCEA itself, or hasn't been shown to? None of that is even admissible so far or authenticated, much less does it establish the culpability of my clients. That is not sufficient. Once again, I don't disagree that something is happening in the world. What I disagree with is that my clients bear statutory and legal responsibility for that, given any of the evidence that's been shown to this court. So this evidence that they go back to, last month it was anonymous tweets and random email responses. Now it's TikTok and this other anonymous email that we got last night at 5:30. None of that was sufficient last month to convince Judge Peterson that a strike was imminent. Whether or not you consider what's going on right now to be a strike, even if you consider it to be concerted, it has to be coordinated, concerted by my clients. So there isn't enough evidence for you to find right now, 1, that it is a strike, that it's concerted. Number 2, that these defendants are responsible for that strike. And further on, and this gets us into the next level, that there are specific constitutionally supportable findings that this court can make and orders you can issue that will enjoin conduct by these defendants that will prevent what you determine you need to prevent. There is no evidence of specific conduct by these defendants that you can order them to stop doing. They're not doing the things that they're being accused of doing. There's no evidence. There's simply, how else could this happen if they weren't doing it? That doesn't rise to the level of injunctions. Furthermore, there's a portion of the proposed order, and I'll get to the rest of it in a second, the sort of proposed request for relief. This is what we want our TRO to look like. That says, make these clients go out and say X, Y, and Z regarding what the penalties are for strike, or please don't strike. Number one, I don't think this court or anyone else is going to force someone to go out and make statements. But even if they do, that's already been done. You've seen our declaration. It's been clearly said out in the open that teacher strikes are legal. It's been clearly said by Mr. Villadita at open meetings that sickouts are illegal. Don't do those things. Furthermore, in Nevada, everyone is presumed to know the law. There's no such thing as an injunction saying go out and tell people the law. It is not even rebuttable. So there's no evidence of involvement of CCEA or these defendants in any alleged or purported sickout of teachers in Clark County. Without that, there can be no injunction against these defendants. But let's just assume, because I'm in the arguendo business, let's just assume that you disagree, that you feel that the emails or TikTok or the inadmissible slide, all those things, sufficient for you to find that there is a strike coordinated by CCEA and the individual defendants, and you have to do something about it here today. Let's assume that. So let's then talk about what an injunction would look like if you were going to do it. Because even the adjoined, like the accused, have certain rights. They are due process rights, right? They are constitutional rights. Obviously you are bound because they will be bound. Everyone has a particular role to play in that. And Rule 65D, to which this injunction, like any other, would be subject, is very specific on the contents of an injunction. Every order granting an injunction and every restraining order must state the reasons why it issued, must state its terms specifically, and describe in reasonable detail, and not by referring to the complaint or other document, the act or acts restrained or required. That's really difficult in this circumstance, I think, because we haven't really identified what's being done that's the nexus between my client's conduct and this purported unlawful teacher strike. What in fact are we going to do that still protects my client's rights to know what they can and can't do? I mean, this is baseline Nevada law. Let me just grab the Mayhew case. I can just read shortly. Here it is. This is from 1972, Mayhew, 88 Nevada 592. It says that an injunctive order is an extraordinary writ subject to contempt for failure to comply and thus must be set out in specific terms. Your Honor is certainly familiar that injunctions are challenged all the time for their vagueness and their overbroad qualities. So the ingredients of a valid injunction here are really hard to formulate. Would we be directing the union or these individuals to control the behavior of individuals? Would we be enjoining teachers from calling in sick? Would we have evidentiary hearings regarding notes from doctors in violation of HIPAA? Would we be doing any of those things? The world of, and look, frankly, I'm a little sympathetic to the court's situation in this regard, because these statutes were written in 1974. I'm old enough to remember 1974 and strikes back then where people got up and walked out of work and walked around with picket signs in front. A lot easier for a court to say, hey, stop that, get back to work, we're enjoining the strike, right? This is not that situation. But the court would still have the responsibility to fashion the injunction in a way that would work. And frankly, the proposed injunction given to you by the plaintiffs does you no good at all. It is all but useless. It says, for example, defendants in the bargaining unit's not even a party here. I don't even know what that means. I guess that means every teacher in Clark County. Even and you read this in the papers, even the half of those that called out that aren't even members. Right? We haven't even talked about that. That half of the teachers that called out sick aren't even CCEA members. So what are we saying that CCEA is now concocting plots among teachers who can't even be bothered to join the union? This doesn't make a lot of sense to me, but continuing. The bargaining unit they represent are enjoined and prohibited from continuing the strike. Now that makes sense, I guess, because the statute says the injunction shall enjoin such strike, right? So the strike will be enjoined. You still have to define what that is, who's doing it, and who's causing it, right? So continuing the strike, which is some generalized term that in this context means make sure the thing we don't want to happen doesn't happen, whether you control it or not. And any other actions which amount to a strike. That's just to follow the law injunction. We don't do those in Nevada. The obey the law injunctions are expressly disfavored as pointless, seriously. If someone's violating the law, you attack that. You don't say, I enjoin you from breaking the law. And then further on, the defendant's order to communicate the terms of this order, communicate potential punishments. We've already talked about that. It is really difficult for me to understand if you get past the notion that there's no definite linkage that, upon which you can rely, that my clients are causing these events among teachers who aren't even members, or that they could control them, that fashion an injunction that would not put my clients unnecessarily at risk of violation when they don't know how to do what the injunction's urging them to do. And that's really serious here, because I just read to you from the Mayhew case that you are subject to contempt under a normal injunction. You would issue an order to show cause, somebody would come in, and you would, the whole range of punishments you could possibly place upon somebody. In this instance, many of the punishments are in fact in statute. Your organization, $50,000 a day. The leadership of the organization, $1,000 a day. Fines to the individuals. Termination of everybody found to have violated the statute. So hundreds of people at this point, I guess, including my clients. All of those things based on an injunction that I don't think can be fashioned in a way that is not vague and overbroad, even if you got past the original evidentiary question. Oh, I didn't even mention the fact that there would be the potential for the union to be decertified as the bargaining unit for these teachers. All of those things would flow from potential violation of an order that I can't at the moment even envision. So I'm gonna stop and answer whatever questions I have for you. But I think those are the two major issues for you. Number one, when I say there's no evidence of what they need against these defendants. Number two, the injunction is impossible to imagine against these defendants for much of the same reason. What are they doing that they now need to stop doing? So I'm going to stop and answer any questions you may have.
I don't have any questions.
Okay.
Thank you. You're very thorough.
Thank you. Can we take 3 minutes for me to consider or reconsider the testimony of my client?
Yes.
Thank you very much.
A short recess, but
Your Honor, can I respond to some of the arguments that
Oh,
he
yes.
made? Can we do that before we take a
you
break?
want to reconsider your
That's fair.
testimony first, and then, because then you won't be finished. So if you're going to have him testify, we need to have that done before we have our response.
Well, that's what I figured. But if you wanted to jump up and say whatever you wanted to, I don't. Everybody gets to say what they're going to say in some order, Your Honor.
So what we're saying is he's deciding if he's going to put his witness on or not. You will have a chance.
Okay, as long as I'll have a chance.
Oh, sure.
I appreciate it.
In fact, you'd have a chance to cross-examine if it comes along. All things will happen. Okay.
3 minutes starts.
Okay. Your Honor, we will submit on the, I'm sorry, we got on the record, I didn't mean to.
We're still on the record.
Oh, very good. Didn't do anything while I was gone, did you? Okay.
Nobody said a word?
We will decline to, we will submit, I guess is what we're saying.
All right, thank you.
Thank you.
Any rebuttal argument?
Yes, Your Honor. So a few different things. The first thing, again, I want to get back to this issue of the real impact here of them claiming we don't have enough evidence of their involvement, but they're able to hide the ball at every turn and are essentially refusing to provide any testimony related to whether or not that's an authentic image. I think that that's an important piece that has to be considered here. But they also talked about they feigned ignorance about what is an exclusive or what is a bargaining unit. Bargaining unit is defined in NRS 288. It's one of the defined terms in the statute, and it also explains that each bargaining unit has an exclusive bargaining agent that represents them. That, in this case, for CCSD educators, are the defendants. That's why they were a party to this. They were a party to this because they made threats of striking, what were plainly threats of striking. In our last hearing, too, one of the things that they argued as a means to why you can't, this is premature, you shouldn't grant this, because these are threats, but they're verbal, it's free speech. We don't know what the union membership is going to do. We don't know if they're going to vote for that. We don't know if they're going to do something else. That was one of their key arguments at the last hearing, was that they act through their members. They are the exclusive bargaining agent for the teachers. What the injunction would do is it would prevent a strike from continuing. They're arguing a lot of general principles about, oh, this is an obey the law injunction, things of that nature. That's how the legislature wrote the statute and intended it. They meant it to be very broad. And they bring up the fact that this was passed a long time ago. Admittedly, it was. But the statute, NRS 288, was looked at by the legislature and was amended, I believe, in 2019 as well, because they added an ability. They changed some of the numbering in the statute, and then they also added an ability for certain executive employees to unionize. And so the legislature has not just had to sit there and never looked at it to determine if they really meant what they meant. They've relooked. What the statute says is that you can issue an injunction to prevent the strike from continuing. They're not denying that a strike is occurring. Really, their only argument is, we didn't do it, but Your Honor, it's the proverbial, you can't lead a horse to water and then say, we didn't make them drink. That's exactly the argument that they're trying to make here right now. We set forth plenty of evidence of Mr. Velardita's statement specifically, where he clearly was setting forth a plan of action related to this, targeting trustees' districts. That's exactly what's occurring. And regardless of if you consider the photo or not, we think it should be considered because they're clearly hiding the ball on that. And there's other evidence that helps corroborate what it is. But obviously, they want to say that we can't control our members, but the court's injunction would enjoin the defendants and their bargaining unit, which is a defined term in the statute that they represent, they're their exclusive agent, and it would prevent a strike from continuing. And then there's a lot of discussion about, well, how are they going to know what to do or not do? They should not strike. It is clear what a definition of strike is. You don't need to invent a definition. You don't need to think of every which way they might continue striking. But the court should set the status quo of what the law requires, that strikes are illegal. They're not even really denying that a strike is ongoing. They're just saying you shouldn't hold us responsible for our members, our bargaining unit. One other point. And I think I've seen this in other places. They brought it up in their briefing. Mr. Schrager brought it up here today as well. this issue of, oh, well, they've admitted that some of the people striking aren't even dues-paying members of the union. We have admitted that. But CCEA itself touts that they are the exclusive bargaining agent for all 18,000 or 19,000 educators in the district. They tout that. They still represent them, and the statutory structure does show that they are the exclusive bargaining agent for all of the educators. Whether the people decide to pay dues to the union or not, they are still reap the benefits or the windfalls of being of what the union is able to negotiate or win in arbitration now that there's been an impasse on the negotiations. And so I just think that that's worth going. And because all of the educators, I'm assuming they all have the same interest in wanting to get paid more money, which is the part of their negotiations, right? And so their interests are aligned. Whether or not they're a dues-paying member of the union or not, their interests are aligned. They're still represented by the union as the exclusive bargaining agent. There's nothing unique about that fact, and clearly the legislature intended for this statute to be broad, to be enforceable, and for the court to enter an injunction exactly like the one that we've entered into it. They talk about concern about the penalties that might come if they violate the court's order, if the court issues an injunction. Of course they're concerned about that, because up until now, and the reason why the injunction is important, up until now they've been able to do what they've done and avoid any actual teeth of the statute. The teeth from the statute comes once an injunction is entered, a preliminary determination by this court that a strike has occurred and that they should be enjoined from continuing that strike. And so the court does not have to think of every which way that they might violate it, but clearly the statute also does not say that automatically those penalties apply. It says the court may apply those penalties. So I would actually think that the injunction is going to be the best thing that will get teachers back in the classroom and stop these actions that they're engaging in, because it will, for the first time, require the union to actually try to get them to stop doing what they're doing. Otherwise, they will not appear reasonable to the court if the strike continues. If they do everything that they can do to try to end the strike, I would presume the court would not issue monetary sanctions against them later, the defendants here. But I don't think that that's a reason not to grant the injunction when the only requirement that the statute requires is to show that a strike has occurred, and then the court can issue an injunction to stop it from continuing. And so I think that's really an important thing. And then the last thing, Your Honor, is if we're to interpret the statute the way that the defendants want the court to interpret the statute, it would basically render it hollow. Because basically what they're saying is we would need to call in here and we would need to file either an individual lawsuit against every single teacher that's absent over the coming weeks. Everyone that's been absent over the past 7 school days, and everyone that keeps happening. And we'd have to keep filing and trying to get new injunctions every time people are out on a pretextual absence. That clearly is not what the statute was intended. All of NRS 288 is about setting up a labor management relations that allows the state and government employers to deal with their unions that the union represents. And so clearly, the whole thing envisions that the defendants in this case would be a party to this action and could have an injunction against them. And so with that, I will, unless you have any other questions for me, I'll step back.
No, I have no questions. Thank you. All right, the court finds that a strike has occurred. And the evidentiary basis for this is mostly based on circumstantial evidence, but an overwhelming amount of circumstantial evidence that cannot be ignored. We have 8 separate schools that had to be closed due to teacher sick call-outs in a period of only 7 days. Provided with the district's last supplement is a picture of a news report that was on Fox News showing the actual locations of the 4 schools yesterday that had to be closed, and they are literally in the 4 corners of the city, north, south, east, and west, completely spread out. The idea that it should be ignored, that these are sick call-outs, and that they are actually due to someone being sick is preposterous. We were talking about 4 schools as far apart in the city as you could possibly be. It is more likely an indicator that there is a concerted effort to do exactly what has been threatened to be done by Mr. Velladarda and other people in public messages, in public comments, and that is to systematically strike. And that's exactly what this court finds that this is. It's essentially circumstantial evidence. We do have an email from one teacher at the Southwest Technical Academy who is a CCA member, but I do not believe it's been asserted that this person is an organizer or anybody high up in the membership, but we do have that email. We have the TikTok account for what that's worth, but essentially the court's decision is based on the overwhelming amount of circumstantial evidence that this is a concerted and coordinated effort and that it is indeed a strike. That having been found under NRS 28870, the court shall, which means must, order an injunction. So the injunction is being ordered. At this time, I think there is, again, more than substantial evidence to establish that based on what I've just reiterated. And the injunction itself, I agree with the defendants here that we do have a little bit of wording issues. The court is not concerned about paragraph 1, which states, in accordance with NRS 2887052, the defendants and the bargaining unit they represent are enjoined and prohibited from continuing the strike and any other actions which amount to a strike as defined in NRS 288.704. The court is in agreement with the district that the strike is defined. This injunction and that language is very clear. Do not strike. Paragraph 2, defendants are ordered to communicate the terms of this order with all with all of the CCEA bargaining unit. That is also, language is not problematic for the court. I think it would be helpful to everyone, and it is part of the reason we have unions to bargain and negotiate and communicate with its members, and I think that would be appropriate. With regard to paragraph 3, defendants are ordered to also communicate the potential punishments found in NRS 288.710 and NRS 288.715 available for continuation of the strike in violation of this court's order with all CCEA bargaining unit. The arguments of the defense is well taken on that. The court is not willing to go so far as to order the bargaining unit or any individual to affirmatively make statements. I think that's a violation of the First Amendment. However, as a courtesy and a help to the community, the court is going to state those on the record now. NRS 288.710, punishment of an employee, organization, labor organization, officer, or employee by the court for commencement or continuation of a strike in violation of the order. 1, if a strike is commenced or continued in violation of an order pursuant to NRS 288.705, the court may A, punish each employee, organization, or labor organization guilty of such violation by a fine of not more than $50,000 against each employee, organization, or labor organization for each day the violation is continued. B, punish any officer of an employee organization or labor organization who is wholly or partly responsible for such violation by a fine of not more than $1,000 for each day of continued violation, or by imprisonment as provided under NRS 22.110, or C, punish any employee of the state or of a local government employer who participates in such strike by ordering the dismissal or suspension of such employee. 2, any of the penalties enumerated in Section 1 may be applied alternatively or cumulatively at the discretion of the court. I'm reading this because I need everyone to know how serious this is. Yes, this legislation is old. It's from the 70s. Maybe in the 70s it was easier to identify what a strike is and easier to enjoin them. However, what's happening here is very clearly a strike that needs to be enjoined. The court is extremely sympathetic to how difficult this situation is. Obviously, we want our students to have good teachers. We want our teachers and our office staff to be fully and completely compensated and have the benefits that they deserve. But in the 70s, the state decided that because of the public service that teachers perform, that these employees perform, they cannot be allowed to strike. You guys are out on the front lines, like the military, like first responders, and there are too many people counting you. There are children counting on you. There are families that need to go to work and feed their families and put roofs over their heads that are counting on you guys to show up and follow the law and abide by the law and do your job. The way you address your concerns is at the bargaining table. It cannot work like this, and that's why there's a law against it. And I'd also like to encourage the district. Obviously, there's a lot of people who feel like the district is not coming to the bargaining table with possibly full good faith. So I'd like to encourage the district to make sure that that is happening as well. And I encourage everyone to get back to the bargaining table and do this according to the law and do it with good faith. So we do need to redraft the order for the injunction, and I'm also ordering the preliminary, I'm not ordering the TPO, I'm ordering the preliminary injunction. So that is going to be granted. Is there any concerns or questions from the council?
Yes, Your Honor. Obviously, you understand it is my duty as an advocate to seek expedited, if not immediate review of your order, which I respect tremendously, correct? To that end, because I have to, I'm going to ask you to stay effective your order pending that appeal, or to tell me that it would be futile to do so that I can ask the Supreme Court to do the same thing under NREP Rule 8. And obviously, the injunction is not in effect until it's served upon the parties, I guess, whether the bargaining units are part. Not important. Obviously, expediting that process so that I have it at hand. I intend probably to notify the Supreme Court to prepare for this on an expedited basis using whatever minutes or anything that I can put together. But the order, I guess, could be today, tomorrow, could be whenever. So just to urge the expedited treatment of that. And again, the issue regarding stay pending appeal.
It would be futile to request a stay.
That's what I
pending
figured.
appeal.
Yes, thank you.
Your Honor, just to point out, and to Mr. Schrager's point, just did you want us to revise the order consistent with your what you recited here today, and then have Mr. Schrager look at it and then submit it to you for signature?
Yes,
Is that
and
okay?
The sooner you get it in, the sooner I'll sign it.
Honestly, Your Honor, it sounds like you're just crossing out number 3.
I agree.
If you were to do
I
that.
wanted to leave it open if you guys want to make any other changes.
I mean, if you wanted to cross out number 3, hand it to her and have her sign it.
Okay. It'll be
fine.
submitted to the DC 19 inbox. We'll exit out and I'll sign it.
Okay.
Okay, we'll submit. We'll do that.
All right, I'll sign that this afternoon then before I start my 1 o'clock work.
Very good, Your Honor.
All right, anything further? Okay, thank you everyone for being here. Off the record.
You've been watching breaking news from the Las Vegas Review-Journal, sponsored by Michael Gaughan's South Point Hotel, Casino, and Spa.